afternoon to all the viewers. I am Dr. Rajesh Singh from Parul Institute of Law, Parul University. I warm welcome our speaker, Mr. S.N. Bhatt Saab, who is the renowned advocate at the Honorable Supreme Court of India. Now, I will just tell about the topic. The topic is very interesting on this webinar. This is the topic on the virtual hearing of the courts and its development. So basically, now the courts in this pandemic is running on the virtual mode. So, sir will going to elaborate how these courts are functioning and what are the advocates are facing the problems and how it is going to be very factual manner what is the current status at the Supreme Court of India. So now I will tell Dr. Akhil Sayyed sir to warm welcome our eminent speaker and let me tell about SN Bhatt Saab. SN Bhatt Saab having a practice of more than 30 years and he is a renowned advocate from the civil as well as the various matters like the contractual matters and all he is dealing with the lots of big matters. So now I will tell Dr. Akhil Sayyed Saab to warm welcome our speaker SN Bhatt Saab and after that we will start our session, sir. Dr. Akhil Sayyed Saab.
Thank you, Dr. Rajesh. Uh, it's our great pleasure that a person like Bhatt Saab is today on the virtual platform of Parul University. Sir, as I was just mentioning, our university is a digital university. We understand and appreciate the importance of this digital era, and our all the classes are being conducted nearly for more than 1 year. Completely online classes we do conduct, and consecutively 3 end semester exam, that is in May 2020, then October, November 2020, and now recently in April also we conduct April 21 also we conducted online exam, and that is the Proctor exam. So the topic which your good self has chosen for today, the virtual hearing of the court. So I am happy that my students who are using this virtual platform for learning and examination, they would be very much conversant and comfortable with the virtual course also. So that is what again a positive side of a pandemic, that perhaps the things which we would not have learned, the use of this artificial intelligence and technology, pandemic has compelled us to do this. And the court, the judicial system, which has never in a plan to convert into the virtual courts, but very soon and very in a short period of time, there is a drastic change in the technology and the usage also. So we all are eager to hear you, sir. I will not take much time. It's our great pleasure. But at the negative side of pandemic, we are not able to welcome you at the university. So once this pandemic is over, I request you to kindly visit physically at our university and see our infrastructure, that the way we have made this as a world-class international university. Thank you, sir. Thank you very much.
Thank you very much. Thank you very much. It is a great pleasure indeed to be with you people, though not physically, at least virtually. Because as you rightly said, the times are really difficult. It is physically impossible to associate oneself with you people physically. But at least virtually we have been able to join again. Last year I had occasion to address people, talk to people on a topic. Parul University had afforded a platform in which I had the occasion to speak. It was a great pleasure on the last occasion also. This time again, I am really happy to join you people. As Mr. Akhil said, the difficult times sometimes spawn or give birth to new innovations. The present crisis, the pandemic for the last 1 year and more, has really forced the hands of the courts and the court administration and the judiciary to resort to virtual hearing. Today's topic is a very topical topic which you people have really invited me to talk about. Earlier, Supreme Court tried, I'm talking about the Supreme Court, various high courts have also tried to use technology and modern science for the purpose of using it for the purpose of delivery of justice. Courts tried tried to persuade advocates and tried to use the platform for filing of cases, pleadings, etc., through email and e-filing. But it did not really take off. It on a large scale, e-filing has not been done in Indian courts so far, especially in Supreme Court. Though there has been a move for the last decade or more to switch over from paper filing to e-filing, things did not really click in the sense that somehow or the other there was no cooperation from the bar to fully, I suppose. The bar was not ready, I suppose, or the advocates also, like old advocates like me, who are not really technologically savvy, would not be readily agreeable to switch over from old method of working to the new method. Somehow or the other, even till today, e-filing has not been come to full vogue in Supreme Court. Even today, most of the cases are being filed, majority of the cases are being filed by paperwork. Physical paper filing is being done. This is a position with regard to filing of cases, pleadings, etc., etc. Though attempt has been made for the last 10 years and more. I distinctly remember that Justice Kehar, when he was Chief Justice, he was very enthusiastic about inaugurating e-filing mode in Supreme Court so that the paperwork is reduced, physical paperwork is reduced. He had tried to bring in elaborate methods for the purpose of put in place elaborate method for that purpose. But during his tenure, it did not really work. Thereafter, 2-3 successive Chief Justices have come and gone. Justice Deepak Mishra, Justice Gogoi, Justice Bobde. They have not been able to really enforce e-filing on full scale in Supreme Court. But as Mr. Akhil just now referred to, the present crisis really forced the hands of both the advocates as well as the judges to switch over to virtual hearing because the physical hearing was ruled out in the courts. That is why they say sometimes, as rightly pointed out by Mr. Akhil, even a crisis or a bad time also has a silver lining in its wake. It brings out certain positive aspects also. So technology has come to has begun, is a savior in that sense. They say necessity is the mother of innovations. This is one of the illustrations of that. What virtual hearing has been fairly successful in Supreme Court, especially. I can tell you from our experience in the Supreme Court, hearings have continuously taken place from Monday to Friday, though not in full scale, in the sense that all the courts functioning all the time. That is because of course, inherent technical difficulties involved, because all the courts cannot possibly sit at the same time at 10:30 as the physical courts used to sit. Earlier, during the hearing of physical courts, all the courts would assemble at the same time, 10:30 in the morning, hear matters up till 1 o'clock, have a lunch break from 1 to 2, 2 o'clock again assemble and go on till 4 o'clock. But then today the situation is that the platform is not capable of sustaining all the courts hearing at the same time. Therefore, they are giving staggered kind of hearing. Some courts sit at 10:30, some at 11, some at 11:30. But then hearing do take place. Except for the last couple of weeks when things have worsened in Delhi. Otherwise, hearings have been taking place on a regular basis. Matters do get listed and advocates do appear virtually, of course, sitting in their respective offices or residences and arguing matters. There is, as far as the functioning of the virtual court is concerned. There are certain drawbacks, of course, in the virtual court hearing. That I will like to dwell upon that in the later part of my talk, because under no circumstances one can possibly say that virtual court would be the same as physical court. As Mr. Akhil again referred to, it is a greater pleasure to meet in person and see somebody in flesh and blood. That has a different dimension altogether, because human beings have multiple sensory perceptions. They want to see, they want to touch, they want to speak, they want to hear, and all these multiple dimensions would not be possible in virtual hearing. So there is that drawback in virtual hearing. But yet, even so, since justice delivery system and judiciary cannot stop functioning, because it is one of the essential aspects of human life, courts have somehow managed to see that there is no stoppage of work in courts. That is a great initiative taken by the Chief Justice of India, as well as judges, especially Justice Honorable Justice Chandrachud. He was he's a forward-looking judge and a very dynamic judge. He was one of the persons who were instrumental in keep making the system come into effective usage. The reason is human life. In human life there are certain aspects which are continuous and ceaseless and relentless, and they do not admit of any pause. One of them is justice delivery system. You have to, they say that the courts should never close. The courts should always be open to litigants who are in need of justice. Those who come to seek justice at any hour of the day, because justice delivery is not a seasonal or a periodic event. It is a continuous and never-ending and ceaseless job. That is why they say lawyers and judges have to work 24 hours, 7 days a week. There is no question of a lawyer who taking a pause and then saying that today I would not be able to work or not able to go to court. There's, as I was sort of mentioning, certain aspects of life one can appreciate it if one can compare with the other professions. If you look at the present pandemic only, certain aspects of life which are relentless and ceaseless, which do not admit of any pause. When I say that, one would say the political process, for example. In a society, political process is a continuous thing. A political leader, a person who is in control of things, who runs the government or runs the system, he cannot say that I will take certain days off. Let the political process be in suspension, and somebody else would take over. No. If he does it, then then immediately he will be vacating the responsibility and shirking his duties. Similarly, judiciary or law and order, because law and order is one thing which is so intricate and so connected with human life that a person, you cannot leave the streets empty of law enforcement agencies. Otherwise, it will be entirely lawless, and you will be leaving the streets to thugs and lawless elements. Therefore, and health, again, health is also a aspect of life, the doctors and hospitals, they have to function all the time without any remedies. That is the reason they say that courts, hospitals, judiciary, law and order, security, all these things in life have to be continuous process. The virtual mode has really helped us in seeing that this process is continued without any pause. I, as I was saying, there are certain facility also in this. People have been trying to, in Supreme Court especially, have been trying to adjust to this new mode of working. Uh, as far as we are concerned, sometimes the paper book is very thick, or when we have to cite decisions and make the judges read the decisions, etc., we find certain amount of practical difficulty in doing that because the judges may not be in a position to immediately retrieve the books from their residential library, or since their residential library would not be having all the books that is necessary for hearing. So elaborate and intricate matters which require long drawn hearing, it is a little difficult in virtual mode for hearing. Only we have been for the last 1 year and odd, matters which require shorter kind of hearing, where admission, especially admission matters, in which one could conclude the argument, make a point, conclude the argument, or highlight a particular thing in 5 to 10 minutes or 15 minutes. So most of the matters that have been heard are of that kind because of the urgency involved in the matters, especially bail matters, those in which prisoners are languishing in jail for a long period, and admission matters, college admission matters, and matters of that kind, which cannot be postponed under any circumstances. Those kind of matters definitely have been effectively dealt with by the Supreme Court. And of course, various high courts also, large number of high courts. As I was saying, this has helped us a lot in overcoming the present crisis. But as I was referring to earlier, this cannot be a permanent solution for hearing. Virtual court, as I see it, unless, of course, the technology one cannot really predict with technology. Technology can, work wonders and may in times to come enable courts to virtually shift over to virtual mode, as so to say. When I was young, I would not have even dreamt of seeing somebody else's face while speaking to him, like we are doing now. Even today, we can. At that time, even to make a phone call, distance phone call, one has to ring up, ask the particular telephone exchange of the particular town to connect one to somebody else in a different town. They would connect and then ring back and say that now you can speak. There was no possibility of anybody speaking to somebody else in some different town or city directly. Later, the STD facility came, which enabled subscribers to directly dial the person in different towns without the assistance or the intervention of telephone operators sitting in the telephone exchange of his town or city. So things today we have come to a position where we can directly speak to somebody and see him at the same time, virtually see his face and talk to him as if he is in person there. So these kind of developments one can expect in times to come, maybe 20, 30 years down the line. One may not be able to rule it out entirely. But at the same time, unless technology really is in a position to replicate the virtual physical court atmosphere, it would be a very, very difficult thing to really substitute physical hearing by virtual hearing, because what physical hearing has advantages and it has its own dynamics, which cannot possibly be supplied by virtual hearing because of certain inherent nature of court hearing and judicial processes. Court hearing is, as you people would know, deal with human problems. Courts and judiciary are human institutions. They are not dealing with the cold, hypothetical, theoretical questions which one may be able to discuss over the phone or over virtually over the over virtual platform. When you have human problems which have to be dealt with by application of legal principles, the mere logic, which is the essence of law, would not be sufficient to solve the problem. Human problems will require human touch. Therefore, a person appearing in court, is his physical presence, the way he presents the case before the court, his very physical presence itself makes a lot of difference in the perception of the problem by the judges. Any experienced judge would tell you that the actual presence of the man and his exposition of his problem is very, very essential for understanding the problem, the case in all its dimensions. When we appear in court, it is very often said by judges that they have read the papers. Very many judges, all the judges in Supreme Court in particular, do come after reading. But yet, they do hear counsel. Well, because mere cold print in the files would not convey the entire story. Even if one reads the papers thoroughly, not once or twice, or even more times, it would not give the entire picture of the problem or in the case involved. It is the presentation of the case, highlighting of a particular problem, the intricacies involved, the human element involved in it. All these aspects require presentation before the court, and that presentation is more effective and could be brought home to the human mind, which is the judge's mind, better and more effectively only when physically you are present before the judge. Therefore, virtual court would not be a full substitute for physical court hearing. But I do say that with the caveat that, of course, in times to come, maybe 30 years down the line, one may be in a position to replicate the physical court's atmosphere in that may be a different matter altogether. But unless that kind of an atmosphere is replicated, where you have the judge in front of you, you are there in flesh and blood, your rival, the opposite party is there in flesh and blood, how they react, what is the body language, all these things do count in court hearing. Because in court hearing, the outcome depends to a large extent on the ability of the counsel, apart from the merit of the case, the ability of the counsel to project the case, the court craft that he possesses. Because to convince a judge, an experienced judge in particular, to the merit of the viewpoint of one's case is an art by itself. That is more effectively carried out if one is physically present and if one is able to discern the reaction more closely, reaction of the judge. I have heard about a very renowned lawyer, because he is a legend in himself. I would not name names. He was capable of, when judges were sitting, and he would make a submission before the court, make a proposition. After a while, the judges, one of the judges, supposing, consult the second judge with regard to the proposition being made by that particular counsel. During the period of discussion, he would keenly observe that discussion. The judges would be sitting about 10 feet away from in the podium. He was in a position to read the lips of the judges and to find out what is the view of the two judges, what is the opinion of the different judges. And even before they would come back to him, he would be ready with his answer, because he would anticipate the question that was being put by that is likely to come, by only guessing what was going on in the mind of the judge by their conversation, that is by lip reading. So that is also an essential quality of court craft, ability to read the mind of the judge through his lip. So these are elements in presentation of the case in court, which may not be fully practiced in virtual court because of its own limitations. You people know the limitations of virtual court, so I do not have to really elaborate on that. This kind of course, we have to make do with whatever is available with us for the time being. We cannot possibly today wish for court hearing with immediate effect because of the present situation. But then I do not foresee virtual hearing overtaking or replacing fully physical hearing. See, there are any number of decisions of the Supreme Court, right? Even Privy Council decisions. They say that while one is, I'm talking about trial court, and I'm not talking about Supreme Court in this context. While recording evidence of the witnesses, the trial judge who has seen the witnesses giving their evidence in court, in person, when he is physically present, sees the demeanor of the witness, his body language, his behavior when he is answering a particular question, and he is in a better position to assess the truthfulness or falsity of the deposition of that witness. Therefore, a trial judge's assessment with regard to the demeanor and the reliability of a witness has to be given due weightage. And the appellate court, which would be only seeing the evidence which is transcribed into paper and reading it in cold print in paper book prepared by the counsel, should not readily or as a matter of course discard or upset the finding of the trial judge, because the trial judge had the evidence of seeing the witness and finding how truthful and reliable the witness is. There again, the element of human touch comes in. These are aspects of legal process, judicial process, which are lacking or would be deficient in virtual mode hearing. There is always, of course, possibility of technology doing something better for us, but then as I see it today, it is very difficult. One more aspect I wanted to advert to, how the physical hearing and the presence of a counsel makes a difference in the mind of the judges and judicial process. I am reminded of an incident which had a case which had taken place long back, which I had heard from somebody else. This is a second-hand knowledge that I have. I cannot really say that it is incident which had occurred 100% in truth, but whether it is a true incident or not, the illustrations drives home the importance of physical hearing and the difference that a counsel, experienced counsel, can make in the decision-making process of the judge. It was said that a young lawyer who had joined the bar just then had about only 2 to 3 years of practice and got his first case. He prepared the facts of the case, law applicable on the subject, read all the relevant decisions on the subject, and prepared thoroughly and went to court to present his case on the day the case was fixed for hearing. He was fully confident that he had a very good case. So he was expecting a favorable decision. When the matter was called out, he began his submissions. It appears that within a minute or two, the judge said that he was dismissing the case. The judge dismissed the case. This decision really was a shock for him, the counsel. And because he was so full of himself and so confident about his case and so inexperienced in the judicial process, he said that he was shocked to hear the decision of the judge. He said, "I'm shocked." The judge took it badly. Judge said that this comment from the counsel, that to a young counsel saying that he was shocked by the decision of the judge, amounted to contempt of the court. The judge said that whatever is the decision of the judge of the court, whether it is in your favor or against you, you are supposed to take it as duly delivered justice. So if you are saying that you are shocked by the decision, it suggested that the judge was not doing justice, and it was implied that there was injustice delivered by the judge, which in turn amounted to contemptuous comment on the part of the counsel. So the judge issued contempt notice to him. The man was, firstly, he had lost a case which according to him was a good case so early in his career. And now secondly, he is he was faced with the contempt of court notice, and
Yes, sir.
he came out of the court with a heavy heart. The matter was the contempt notice was fixed for a month or so hence. So he was desperate. He talked to one of the senior members of the bar and asked him, this is the problem. The court had asked him to reply for the contempt notice, and he related whatever had happened in the court. The senior counsels, it seems, said that all right, senior counsel would go and appear on his behalf and defend him with the judge for in the contempt matter. When the matter was listed, the contempt matter was listed about a month or so later. The senior counsel, along with the youngster, went to the court. And the senior counsel said to the judge that it was really unfortunate that the young lawyer said the words that he was shocked to hear the verdict of the court. He never meant any disrespect to the court. He had all the respect and regard for the court. And he was, in his enthusiasm and inexperience, he made the remark and therefore wanted the court to kindly excuse the man. He had a very bright future, so he was regretful of his action. And lastly, he said he is inexperienced. With experience, he would know that no decision of the court would ever shock him. Meaning that he said that with our experience, we are not shocked by any decision of the court. Meaning thereby, he said the same thing which the youngster said. There are shocking decisions of the court, but he put it in some other phraseology. This the judge understood. He laughed at the senior counsel and said that all right, he may go now. He discharged the contempt notice. Therefore, the experience, the X factor involved of experienced counsel appearing in court, depicting a particular human problem. Because as I started, the court is a human institution dealing with human problems. Therefore, human touch and human presence in the court and courtroom and court hall is the most important factor. That is the X factor in the judicial process, which cannot be excluded from the entire thing. So therefore, all said and done, though we have today as a stopgap measure with the limited resources taken to this technology, because we are left with no other alternative. Ultimately, we will have to fall back upon physical court hearing. And I hope and pray that it will soon come about, because things are, as of now, as you people know, are tough, very difficult for everybody. But in due time, I suppose, sooner than later, we would switch back to our physical court hearing. I am really happy to speak and give my limited and understanding of the subject. My views on this on the subject, a very topical subject. I am happy and grateful to Mr. Akhil and Mr. Rajesh for
Yes, sir.
having afforded this opportunity to you to talk to you.
Yes, sir.
As suggested by Mr. Akhil, I would like to physically meet you people next time around,
Yes, sir.
especially in more pleasant and happier circumstances.
Yes.
Thank you very much.
Sir, it was really a fantastic session by you, sir. firstly, you have elaborated the basic aspect of the virtual hearing, that this technology, because the pandemic has made to this virtual hearing. Secondly, sir, you have already elaborated the various practical aspect, like the juniors which you have elaborated. I am also really shocked because if a person who is first time hearing and he is prepared with very full enthusiasm, and I know when I was also argued before Justice Bobde in one of the matter of the 302, and sir, when I was on that day whole night, I was shocked because I know that in court number 12 I have to argue, and it is a matter of bail application. And but my argument was superb, means for 5 minutes just I argued and I got the notice. But sir, we are very much fear on the first hearing that what the court will do, because I know that you people also have started the first hearing, and in the first hearing it is a very means fearful moment. So, but as per your talk, I himself is agree that the physical hearing is more accurate one, because the judges can understand your body language, what you want to say. In some time in the virtual hearing, the judges are listening but they are unable to express what you want to say. Sometime it is not every time, because the senior lawyers have a lots of experience, they will elaborate with the case law and with the rule of the law, and whatever the natural law they will apply as per their rules. But what I considered as an evidence, it is very much difficult to take the evidence in the virtual, because as you have perfectly and specifically you have stated that in the trial courts, when the trial is running, because in the trial there is an exhibit, there is a cross examination, and examination in chief is there first of all, because the person has to put up the case, the fact of the case. So it is a very difficult task in the trial court. And sir, particularly at Gujarat, at Vadodara, where I am, where this our university is there, and nearby we have a court. Sir, I personally go to the court to see the conditions of the courts. So I found that it is very much difficult to, because the judges will give the dates. Okay, you come after these dates. So the litigation in this virtual mode is more pending, because when the trial court will not run, what the high court and what the supreme court will do, because until the matter will not
That's
be
right.
completed,
That's right. Yes.
until and unless the matter is not been exhibited, or not every examination, let us suppose a forensic examination is there, so he has to come in the court and he has to present his evidence. So until and unless this all process is not completed, how this,
That's
when
right.
the trial is not completed, it is
That's right.
going to VTL, and
That's right.
the longer and unnecessarily. And even though, sir, if I will talk about the jail right now, I visited certain jails also at Vadodara. We have a very good jail. Now the peoples are having a pandemic situation, and there are various people who are with the corona. So even though now the courts are giving for immediately bail, this payroll and all immediately, because this is going to make all the people
Yes,
corona
spread.
pandemics.
Yes, spreading,
Yes. So
risk of spreading
so
it.
now so now the basic aspect is what, that okay, in Supreme Court it is the condition is okay. But in the trial courts, if I personally, because I visit the courts and all the friends are there with me of the session courts, so they also tell that the trial process is very very unhaphazardly, because they are not taking the cases, and they will put the cases later, okay, this after 1 month or after 15 days. So it becomes a very difficult situation, because until and unless the trial will not complete, then where you can challenge in the high court, or where you will go in the Supreme Court. But as per the Supreme Court is concerned, sir, as per your talk, which I understand that really, no doubt, virtual courts are there, and virtual courts is better for the people right now. But the physical hearing is really change the scenario of the case. That is very perfect, sir. Which I am also agree with your aspect, because the body language, because immediately the judge will understand what you want to speak with your body language itself, isn't it,
That's
sir?
right. That's right. That's
So
right.
on this platform, sir, we are very much thankful to you, and we have really learned from you on this aspect. And we will, as already Akhil sir has told, that after this pandemic, when this over, sir, really we want, because this is the second time you have devoted to our students, and really we want that you should be one time at our university, sir. So
Thank
thanks a
you.
lot, sir, for giving this time to our student, and we will wish you that this pandemic will get early
Yeah,
over.
we
And
all of us get over this particular
yes,
difficult
sir.
time with
Yes, sir.
God's grace. May God bless you all and
Okay, sir.
us
Okay, sir.
all.
Thanks a lot, sir. Pranam,
Thank
sir.
you.
Pranam.
Thank
Thank you, sir.
you.
Thanks a lot, sir.
Thank you.
Okay, sir. Okay, to Jiten bhai. Jiten bhai. Jiten Kubani, sir. I am also thankful to you, sir. Jiten, sir, are you there? I think he is in another webinar, sir. So we
All
will
right.
close this, sir. Okay, sir.
Okay. Thank you.
Thank you.